right, good morning, everybody. We have 11 o'clock here. Should I say good morning? I always get confused whether it should be morning or afternoon once you hit 10:30 when McDonald's stops serving breakfast. But regardless, I'm going to go ahead and say good morning here since we're early in the week. We have 11 o'clock this morning. Very grateful for everybody joining us today for our boundary adjustment webinar. This webinar is being hosted by the Land Use Academy of Utah and the Office of the Property Rights Ombudsman with funding support through the Land Use Training Fund. My name is Rob Terry. I have the opportunity to serve as the statewide Land Use Training Director for the state of Utah, and I'm housed in the Office of the Property Rights Ombudsman. Before we get started with our presentation today, just wanted to go over a few housekeeping items to ensure that everybody knows what to expect from our meeting. Today's webinar is set to run from 11 a.m. through 1 p.m., including question and answer near the end of the session. This webinar is being recorded, and it will be posted on the Land Use Academy of Utah website for future viewing. That website address is luau.utah.gov. When the video is available, a link will be sent to all registrants for easy reference. With over 200 registrants and attendees at today's webinar, you will note that only the presenters have video and audio available. Throughout the presentation, attendees can use the Q&A function to type in their questions, and the moderators and panelists will monitor that function and collect those questions for addressing during the question and answer portion of the webinar after John's presentation. Attendees will also be able to raise their hand during that Q&A session, and the moderator can unmute them to ask a live question. If that does get a little unwieldy with the amount of attendees that we have, we may disable that, but just want to make sure that everybody knows that that likely should be a function for us to use to have some live Q&A as well and be a little more interactive. Of course, if you have any technical issues during the webinar, please feel free to contact me directly via the chat and let me know what the issue might be, and we'll make sure we can address it. So introducing our presenting team today. Today's presentation will be led by John B. Stahl of Cornerstone Professional Land Survey Incorporated. John has nearly 50 years of experience in professional land use and surveying, and he was deeply involved in the crafting of Utah Senate Bill 104, which introduced several substantial changes to both the Utah Municipal and County Land Use Development and Management Acts and their related statutory provisions. Today, he's going to be covering the new boundary adjustment process. He's going to provide an overview of new terminology, changes in statute, and technical and conformance updates that are critical for practitioners to understand. During the Q&A portion of the webinar, he's also going to be supported by Shelley Brennan, Duchesne County Recorder, Court Ashton, Vice President and Commercial Escrow Officer for Cottonwood Title Insurance Agency, and Zach Shaw, who serves as the Deputy District Attorney for Salt Lake County. So with all of that housekeeping out of the way, John, I'm going to hand it over to you to get the presentation started.
All right. Thank you, Rob. Very much appreciate this opportunity. I think it's going to be an important one for the state of Utah at this point with all the modifications and changes and nuances that are going to happen with this new boundary line amendments bill that was passed through the Senate and through the House this last legislative session. Senate Bill 104 makes some numerous changes and modifications and does a lot of cleanup and introduces some new concepts as well that we all need to be on board with and in order to get this thing underway. The bill was signed by Governor Cox and will become effective May 7th, so just a few weeks from now. And hopefully we can all be as prepared as possible to be ready to be up and running on May 7th with these new changes in mind and in motion. I want to thank the panel members, Court Ashton, Zach Shaw, and Shelley Brennan for joining us today for the Q&A session. I'll go through my presentation for the most part and take up the first hour and a half maybe. I'll try and leave as much room as possible for Q&A at the end. If it's anything like the presentations we've made so far discussing this at the Utah Council of Land Surveyors our conference down in St. George, did a presentation there, as well as a presentation just last week to a couple of chapters of the Utah Council of Land Surveyors as well. This is a bill that really affects the land surveyors and how we deal with landowners and how we deal with fixing boundary problems. So with that, I will proceed, and if you have any questions or at all during the session, please enter them in your chat room, and then we'll deal with all those questions toward the end. So boundary line amendments, Senate Bill number 104. Introduce some new terminology that we'll have to get used to, and I'm still getting used to it, even as much as I've been involved in this in the preparation and presentation of this bill. There's some new terminologies that we've got to break some old habits and get into some new ones, because some of the terms we used to use don't even exist anymore. We'll get into that. The revised boundary establishment procedures, the processes that we have to go through now, and that we've spelled out in this legislation, boundary establishment procedures and boundary adjustment procedures. Now, boundary establishments, we're used to calling those boundary agreements. They're now called boundary establishments. And then we have boundary adjustments. Each one of those have separate procedures that are involved, because they're two different types of agreements that landowners commonly enter into. The recording and documentation standards, we've finally now have spelled out, here's what the documents need to look like or to contain, and what information they need to contain in order to be recorded for posterity, so we can understand what was being done and what were the intent of the landowners in the process of preparing these documents. So we also have done a few modifications in the Senate Bill 104 to the subdivision laws through LUDMA, and some minor modifications there that I'll hit on those that aren't quite as related to the boundary establishments and boundary adjustments, but yet will have some effect on how we handle subdivisions, subdivision platting amendments, things like that. The boundary establishment documents, we'll get into some detail of what specifically they should contain, what's required, what's optional, things like that. And we provided some examples through handout materials, and I don't know that Rob has mentioned where or how to get a hold of those, but someplace we've got some handout materials that are available as examples or sample documents, so you can kind of visualize at least what we're trying to portray here.
Just to jump in on that one, John,
sure.
All registrants should have received an email that had all of the attachments that had been provided in the last hour.
Okay, good. Thanks. Thank you very much, Rob. So you might be able to, if you've got access to those documents, just kind of follow along somewhat with those documents, and I will be using some of them as some examples and talking directly about those. Then we're going to conclude with some Q&A and see what we can glean from this bill. So I want to, before I get into it too far, I want to really compliment and share our appreciation for Senator Musselman, who was the lead senator who took on this task through the legislature, as well as his co-sponsor, Paul Cutler, who came in when we ended up on the House floor. He did the presentation there. But Senator Musselman put hours and hours and hours in phone calls and discussions and meetings, and I really want to make sure that he is well appreciated by all of us for his work. And then the work of all the others that helped through this bill. We spent very intently in the last year, but actually in the last 2 and 3 years, developing this bill. And during that process, we had many meetings, phone calls, emails, modifications, changes, suggestions, discussions that went on, and we had some excellent input. Now, when I say we, I'm typically talking about Utah Council of Land Surveyors and the Legislative Committee, who really started the push on this thing and are the ones that retained Cal Musselman through our lobbyist to present this bill for us. But it isn't only our bill. We depended heavily on the other players from Utah League of Cities and Towns, Association of Counties, Property Rights Coalition, and the Utah Land Title Association. We met with many representatives from those groups. I didn't name them individually because there are too many. So we received input from all of these groups and all these associations, gathered that input, massaged and cleaned and changed, and just worked this bill to its current state that was ultimately passed without a single negative vote. We had full support through the legislative and sessions. I wanted to give you a little bit of background, not to delay too much, but yeah, why muck with a good thing, right? Because we've started mucking with it in 2001. Surveyors were having a hard time defining or separating from most of the title companies' thinking and most of the recorders and the title documents that we see. There's this provision in the law that allows landowners to fix their boundaries and to enter into agreement with the neighbor to resolve any discrepancies, disputes, ambiguities that they have on their boundaries, and to do that without intervention from government agencies or anybody. As long as they have an agreement with their neighbor to do it, the law actually allows them to do it even if they do it wrong. We had initially, back in 2001, created this portion of the code 57-145, Title 57, deals with conveyances of property. And we created this 57-145 to define specifically what a boundary agreement was and tried to distinguish it from a boundary adjustment, the adjustment process that goes through the reviews and changes property. So we started out with that, and we thought we had it fairly cleaned up, thought the language had a few little tweaks that we needed to do. So it lasted for about 10 years. 2011, we had to go in and clarify some of the terminologies and made it a little more in harmony with what the current case law was happening. Resolve some discrepancies there. Then in 2013, only 2 years after that, it got to a place where people still didn't understand the difference between the adjustments and agreements. And so one of the representatives actually created 2 paragraphs. Paragraph 522 and 523 are actually 523 and 524, depending on if you're in the city or county codes, and introduced these 2 lines, 2 sentences in the code. Said boundary agreements don't get review and boundary adjustments don't get review. So nothing was reviewed as of 2013. And then by 2019, we started seeing modifications of the language again, and made it a little more difficult to get through the processes, and kind of started to meld these 2 processes together and getting confused. Title 57-145 in the 21 session went in and did some fairly really some pretty extensive modifications. And then in 2022, there was a major rewrite that completely melded the 2 things together and basically said everything has to be reviewed. So that kind of started a big overload with a lot of the cities, and really required some major modifications because of some misunderstandings and such there. And so that's what hopefully the 2025 bill will actually resolve all the problems created in 2022 and some of their progeny. So it's been a long road to get where we are now. Practically 25 years that we've been messing with this thing, trying to get it, make it an understandable piece of legislation. For those who aren't familiar with the state code as much, there is Title 10 and it deals with city codes, and Title 17 deals with county codes. Chapter 9A is what's called the LUDMA, Land Use Development Management Act. So you have 10.9A and you have a 17.9A. They're basically the same statutes, very slight modifications, but there are two separate sets of code that we deal with. Under the Chapter 9A, you have the 100 series sections, the 500 series, and the 600 series. 600 series deals mostly with subdivisions. 500 deals with the land use regulations, and the 100 series is like a general umbrella act or statute that, in particular, we with Senate Bill 104 ended up making modifications to this series of codes. Let me see if I can do it this way. We had this series of codes that were the definitions. We had to modify some definitions. We had to modify what 523 and 522 were doing. We had to make more modifications for the boundary adjustment process, the boundary establishment process, plat exemptions in 605, and plat amendments in 608. Some of those, all of those sections have been involved in this 104. So you'll see where this 104 reaches around and touches many of those sections of code, and some to a fairly lengthy deal, others not so much, just a few word changes. Then you have Title 57. Well, that's over in more of the title side of the code. Title 57 deals with real estate. Chapter 1 of Title 57 deals with real estate conveyances of title, deeds, and such, and describes everything you need to know about deeds, or probably more than you wanted to know. But in Title 40, Section 45, that's where we had the 57-145 from 2001 created. Well, we modified that a fair amount to update it to the new language that we were introducing with Senate Bill 104. And we added a completely new section of 57-145.5 dealing with boundary adjustments. And this is a new section in the law now that tells you what the documents look like that will be used for boundary adjustments. What information, not necessarily what the documents look like, but what information has to be on those documents. So some of the new technology or new terminology that we've updated. We have boundary adjustments, and they're found in definitions in Section 103 of the 10.9A. You'll see boundary adjustments defined, and you'll find a definition for the term boundary establishment. Those are the two primary types of documents we will be preparing. They serve two completely different purposes under the law. Boundary adjustments is when two neighbors get together and they say, can I buy 5 feet of your properties and add it to mine? Or can we relocate the boundary so that it maybe cuts off a couple of triangles, and I'll trade you a triangle in the front, you can have the triangle in the back, so we don't mess our areas up and things like that. But whatever agreements they want to come to create a new boundary where they know it's never been. They're creating a new line, and they are relocating then the line that exists to a new position. So in that relocation process, because in order to create a new boundary, there has to be a conveyance of title. And so there has to be language of cross conveyance that creates this new boundary between the two parties. And you may have more than two parties as well, but it's going to create that new boundary, and that with the landowners intend on creating the new boundary. The only caveat is that they can move as many of these boundaries as they want to between themselves, as long as they don't increase the number of properties. So if they start out with 2 parcels adjoining each other, they can move that boundary anywhere they want, as long as they don't create a 3rd parcel. They can start with 2 parcels, end with 2 parcels, it's fine. Start with 2 parcels and end with 1 parcel where they combine 2 parcels, that's fine as well, as long as they don't increase the number of parcels. And there are more caveats that we'll talk about. The boundary establishment process, that is what we used to refer to as boundary agreements. To establish the location of a boundary is a separate type of issue. The landowners are getting together because they have an issue, they have a problem. Their deeds might misclose. There's a number of, maybe the surveyor, they've got 2 surveys that disagree, any number of problems. You might have ambiguities or that are within the written documents themselves, their deeds. Well, they're the only 2 people who can actually fix this are the 2 adjoining landowners. It's their property, they can fix it. So they're fixing some kind of a problem. And the courts have defined that as an ambiguity, an uncertainty, or a dispute. There may be a dispute that's arisen that they need to resolve this dispute. So they're going to get together, enter into an agreement that says, you know, boundary, you say it's here, we say it's there, survey says there, deed says here, whatever. We're going to resolve this problem by saying the boundary is here. And they establish the location of the boundary itself. There's no intent to create a new boundary. There's no intent to convey any property. They already own to their boundary. They just don't know where it is. So they're going to just agree, here's our boundary. And that's a simple process that's allowed under the constitutional, they have the constitutional right to enter a contract and resolve a problem between themselves. And so that's kind of where it's going. What is the catalyst then for this agreement? There's a reason they have an agreement, or they're entering this agreement to resolve a dispute or an ambiguity or an uncertainty. And that's the reason that they're going to have this dispute or have this agreement to resolve that problem. And again, it's not going to create any new lots. It's not going to do anything like that. It's not really technically the way that in the courts have this simple mentality that they look at it and say, all they're doing is agreeing where the boundary line always has been. And so they're not changing the size, they're not conveying property, they're not doing anything that's going to affect their legal descriptions or anything. And so when we look at the details, keep that in mind, that all they're doing is saying, yeah, the boundary could be here, could be here, could be here. So let's get an agreement that says it's here. And they establish the location of that boundary. Now that's under 10.9A and 1727A 103, the definitions portion of the code. There's also now, because we have this new code over in the title code, we also deal with somewhat with these definitions there. So you'll see kind of in 2 different places. The Title 10, Title 17 is in a code by itself, separate from Title 57 in the title code. I've noted here some of how we've defined those terms in 57, in 45.5, which is the new section for boundary adjustments. And then 57.145, that's the existing code for boundary agreements that has been modified. That basically says, you know, the same thing, but it's over there in another section of the code. And you'll see that with this bill, that sometimes you'll see bits and pieces in different locations, dealing with slightly different perspectives and aspects, whether it's process or the documentation or how that works. So when we're talking about boundary adjustments, so we've got boundary establishments and boundary adjustments, so the 2 main divisions. Well, in boundary adjustments, there's actually a division there. There are simple adjustments and there are full adjustments. Full adjustments require more more close look at the full adjustment. Simple adjustments are just like they sound. 2 landowners say, yeah, we've got a boundary between us, but we want to move it over to here. I want to buy 5 feet of your neighbor's property. Something that they want to do this, And really, the only question is, well, does it violate a zoning ordinance, frontage, area, anything like that? That's, excuse me, one of the main, one of the questions that has to be answered. And there's really only three things that have to be answered to say, yes, you can do a simple adjustment. It does not affect any public right of way, public easement, or public property. So yeah, if it affects public interests in land, well, that's going to take a more close review to deal with those public entities, making sure that they're all on board. Does it impact any existing easements or wastewater systems, septic tank drain field issues, their regulations? They have setbacks for those. Internal lot restrictions. Anything that's regulatory type issues. And so if you're going to, by existing easements, well, you've got multiple parties potentially there. You might be utility company easement. It might be, say, somebody's private access easement. Well, those parties would need to be involved in anything in order to change the location or adjust that those easements. And then the third thing is that whatever they're going to do, making sure that it doesn't violate a land use regulation, minimum area frontage, side yard setbacks, those type of regulations, zoning issues. And if it does not affect those three things, then it's a simple adjustment. Yeah, you can move this boundary and you're not affecting any of those issues. And so, yeah, the landlord can agree to move the line because it'll comply with the zoning ordinance. A full adjustment now, if you look at the definition, is, well, if a full adjustment means an adjustment that is not a simple boundary adjustment. Yeah, if it's either simple, meets these three requirements, it's simple, or it's not. If it's not a simple, then it's a full adjustment. That needs more scrutiny and will be reviewed at greater length. Couple of terms that we don't use anymore: lot line adjustments, parcel boundary adjustments. We took a step back here and looked at, well, the code used to say, well, you can adjust the line between two lots, you can adjust the line between two parcels, you can adjust the lines between a lot and a parcel, you can adjust a line between a lot and a parcel outside of the subdivision. So you're adjusting the subdivision boundary, and those were all spelled out in the code. And it was like, well, you can basically adjust all your boundaries. If you've got a boundary between two landowners, they can adjust it. And it doesn't really matter what kind or how that boundary was created, they can adjust it as between themselves. And so we got rid of or removed the lot line adjustment, parcel boundary adjustment, and the term boundary agreement also went away because now it's called a boundary establishment, an agreement to establish your boundary. So those terms we've got to try and get away from now and modify or update to these newer terms where you have a boundary establishment and a simple boundary adjustment or a full boundary adjustment. What are those three things? The boundary establishments now we're talking about paragraphs 524, 523 in the city and county codes that kind of predate the 600 series, right? We're in the 500 series. Those are the two codes that started out being two sentences that said you don't review anything. So we've done some extensive modifications in those two paragraphs. Basically, with a boundary establishment, talking specifically about establishments, the owners can initiate this boundary establishment to resolve an ambiguous, uncertain, or disputed boundary by recording an agreement on the location of the existing common boundary. So they're just fixing the location of a boundary that already exists between them that they don't know where it is. There's ambiguity, there's dispute, uncertainty, could be here, could be there, right? So they can do that, and they're allowed to do that under the law. The courts who have upheld these agreements, we've been doing these agreements for hundreds of years. Everybody does them a little different, but the concept is the same. So the difference that we have here now is that we're going to have a boundary establishment document that has to have a certain elements in that document. So the adjoining property owners shall prepare an establishment document that conforms to the 57-145 code and record that establishment with the county recorder. So they prepare a document in accordance with the paragraph 45 over in title, and they record it. And it's a simple process. It's as simple as the process can ever get. But it only is designed for resolving problems. You can't use this boundary establishment process to circumvent what you know is a boundary adjustment, creating a new boundary. Two totally different things for two totally different reasons. Boundary establishments are not subject to review by the land use authority. There's no review process. The code says, here's what the document has to have in it. Here's what you do. You record it. It's done. Boundary establishment presumptively does not affect pre-existing easements, and it is presumed to convey the ownership to the established boundary, so that they already own to their boundary. All they're doing is establishing its location, and they own up to it. So there isn't necessarily any intention to convey title, but yet we want the law to be clear that it's as if, even without that language, it's to be treated, and it's presumed that the title is going to extend to that established boundary. Then we have boundary adjustment procedures. That's spelled out in 523 and 522 of the code, where we have simple boundary adjustments. And those, of course, are the ones that have no impact on public easements, rights of ways. If you want to move a street, well, no, the public needs to be involved in that. And so there's going to be more scrutiny, and maybe even a public hearing required. Number of different steps to go through to make sure that public has a say in moving their boundary, or a boundary that they have an interest in. Land use conformity, rights of ways, public easements, public utility easements shown on a plat, that PUE that's defined over in state code, public utility easement. Yeah, those things if you're gonna be moving those, it's not a simple adjustment now. But you'd have to have, on all adjustments, simple or full, have to go through an initial review process. And the code is now going to be very clear that land use authority shall provide a notice of consent for a simple adjustment. They also have to provide it for a full adjustment. That's going to be slightly different consent notice, but you go in for a review process, and they look at it, make sure they check those 3 boxes, and then if you're good to go and you can do your simple adjustment, they hand you a notice of consent that is attached to the document that gets recorded, or at least made part of that document that gets recorded. The land use authority provides that notice of consent. This was hopefully was intended to be an administrative process, and we'll see that in the language here. Benefits, it's the very next paragraph. Consent is an administrative act. Clarifies that the land use authority is not liable for any errors. They consent to the recording of the boundary adjustment. That's all they're doing. And by doing that, they're saying it doesn't affect any public right of way, public easement, or public property. It doesn't affect any easements, third-party easements or public utility easements, wastewater system, or internal lot restriction. And it does not cause a non-conformity with the land use regulations. Those are the three boxes that the land use authority will check. And if they can check all three things that doesn't affect any of that, then you're doing a simple adjustment. They hand you your certificate and you're on your way. There's no further review required. Proposal for a simple adjustment. All that's provided to the land use authority is the conveyance document that complies with the 57-145.5. That's the new section in the code. And describes all affected lots and parcels. It's got to have a legal description of every parcel that's affected in the adjustment. And that's part of the conveyance document requirements that you'll see in that other section of the code. What is included in the document. Full boundary adjustments. So we just covered simple boundary adjustments here. Well, full boundary adjustments, those are found, that says it must include the conveyance document. The conveyance document, let's just jump down to here, administrative consent. You have to get that same review. You've got to come away with, when you're done with this notice of consent from the land use authority. But in order to get that land use, notice of consent, you're required to go through a few more hurdles. You take the document in for review, going to have your conveyance document is required that complies with the statute. You're going to have a survey done. This is the only one that requires a survey. Now, you may see surveys in the other ones, but that's at the request of the owner. They're not required to have a survey done unless there's something comes up and there's some questions about, setbacks or whatever. In a simple adjustment, there's some complications there. Yeah, they may need to have a survey done. And a lot of these you'll see surveys done because they need descriptions. They need legal descriptions prepared. But a full adjustment requires a survey, and there are specific requirements, things that need to be shown on that survey. And most specifically, the survey shows that there's no violation of land use regulations. Because if it shows a violation, well, of course, you're not going to approve it unless you get a Board of Adjustment variance and go through the variance request in order to say, yeah, okay, we get a variance for that regulation. Well, okay, then we wouldn't have a violation. But the survey's got to have no violation to be ready to go. And if required, you might have to do a plat amendment. And that's the plat amendment process is found in section 608. And the plat amendment process will take you through a public hearing process or a public meetings, at least a public notification process in order to get that approval. That notification process for amended plats is really the same mode notification for a full review, full boundary adjustment. You may have to go through that full process. You want to relocate a street, for instance, a public road. Well, yeah, it's going to take a full public hearing, public review. You want to do anything that affects the public interest in a certain way, then you'll end up going through that public review process. Now, you may or may not have to do an amended plat, even though you're going through an amended plat process. The new code really opens up the style of the document such that the requirements for a conveyance document under 57-145.5, those requirements actually include everything you'd put on an amended plat and a couple of extra things on top of that. And so it really, the conveyance document fulfills all the needs of an amended plat. So we don't even really need to even call them amended plats at this point. You can do a full boundary adjustment, and you're going through all the same process or similar process as you would with an amended plat. There are some exemptions from amended plat processes, things like that. Those are all still apply. We've got some slight modifications we'll talk about. So that's a concept that's going to be a mind bender. Because we're used to doing amended plats. Well, now we're doing boundary adjustments, kind of in the form of, or taking the form of the process for approval of our adjustment, and adding a couple of extra things that need to be on there that an amended plat doesn't even have. So the statute actually states that if it's required by a specific ordinance, passage of a specific ordinance by the municipality or the county, if they pass an ordinance that requires a plat, well, amended plat, okay, then you're going to have to amend a plat. But the necessity for the ordinance really isn't like it used to be. And you may not want to have an ordinance that says we got to go through a full amended plat process, when really, no, we're going to go through an adjustment process that's very similar, yet more distinct. And we'll talk some more about that. You'll see the differences happen when I get to them. The end result of going through the review process, then, whether that's a full public hearing or what, that result comes back with an approval that the land use authority can now issue their consent to the notice of consent. And so that's ultimately then the notice of consent is issued by the land use authority. Now you would attach or incorporate that with your document, and you can now record your full boundary adjustment. It still is an administrative act. The actual notice of consent is still the administrative act, but it will it'll take place after the hearing process. Recording and documentation standards. Now we're talking about over in the paragraphs 45 for simple adjustment, or for boundary establishments, and 45.5 for boundary adjustments, right? So we're over in the title documents code now. In that section of the code, that's where it's defined what these documents need to have. What parts and pieces need to be in those documents to qualify for these recordings. And boundary establishment documents, because it's a very simple process, has fewer requirements. But it is required to have name, address, notarized signatures of each of the property owners that are involved, whether that's 2 or 20. Or I've done boundary adjustments with 7 different parcels all together in one document. 13 pages worth of document, but notarizations of signatures and names, addresses of the parties. The name and address has to be there so that the assessor can assess and properly assess and send tax notices out. The existing property descriptions and the tax identification number, if your county is requiring those, the tax identification number has to be on there, and the address of the property itself. Then you have to have a description of the agreed boundary. That's the only legal description you have, is the boundary. There's no new descriptions of the properties, because you're only establishing the location of the boundary, and it doesn't affect the parcel descriptions or the lot descriptions that the property owners own. So with the boundary establishment, that's what really makes it unique, is that you've got the 2 descriptions coming in of 2, if you're a boundary between 2 parcels, you'll have 2 existing descriptions coming into the document. So the chains of title go into this document, and then coming out of it is the same descriptions, unchanged, but a description that establishes the location of their common boundary. It doesn't affect the other boundaries of the property, only the common boundary. That's why the descriptions don't change, is because there's nothing on the perimeters that is being agreed to, just only the one boundary that's being established. It describes the ambiguity, uncertainty, or dispute being resolved. It's very important to know, well, what is the problem that you're fixing? Why are these people entering into this agreement? It's a requirement under the common law, and it's a requirement now under the statute. The parties have to admit, yes, we have two adjoining deeds that overlap. We have surveys that are in two different places, where we have a dispute that's arisen between what the title shows and where the occupation is, or we have a dispute between the occupation and the survey. It can be a number of different things, right? But specifically, then you'd have the parties are required to say, here's the problem that we need to fix. And because of that problem, here's what we're doing to fix it. We're establishing the boundary here, according to this new description of the boundary. Then they'd have to have a graphical exhibit that's attached to their document or part of the document itself. And the graphical exhibit will have to also have some specific things that it shows that we'll talk about here in a little bit. There's also reference to a survey if there's one conducted. Survey is not required for an establishment, but if a survey has been performed to prepare descriptions and all that stuff like need to be done, and then if you did a survey, the survey will be filed with the county surveyor's office, and on your document that is recorded, you need to make a reference to the survey, so that your document that's recorded in the recorder's office tells somebody, oh, go look at the survey, and the survey will have a lot more detailed information about where this boundary is, what happened, why it's there, whatever documentation that's needed on the survey. It'll show a lot more detail than you'll see on this graphical exhibit. The graphic exhibit is intended to, where if you pick one of these documents up, you can flip to that exhibit attached and see a picture of, okay, yeah, here's the properties and here's where they've established the boundary. And so that somebody knows, okay, yeah, it's that boundary between these two parcels. Just generic location, enough to visualize, so somebody can visualize what these things look like. The layman, the typical landowner, they don't know that legal description and reading descriptions. They don't understand that, but they can pretty well understand what a picture shows. And that's why the graphical exhibit is required. And let's see, next one we've got is the record of survey that goes with that boundary establishment has to have certain requirements. But every situation is different. So you can't say, okay, show all the buildings if there are no buildings to show, right? And so that's why we say the required content may include existing dwellings, outbuildings, improvements. Could be landscaping, could be fences, could be any kind of physical feature, a ditch, irrigation ditch, anything that is near that boundary that may affect its position or explain why it's established where it is. Any kind of physical features. Also showing existing easements or rights of way or conditions, restrictions that might be recorded against the property that might affect where this boundary is. You may have some, you may not have any. So you may, if they're there, show them on the survey. The location of the established boundary tied to a corner of record. There's a definition in the surveyor statute of what a corner of record means. It can be a block corner, it can be a lot corner, it can be a section corner or quarter corners, something with the public land survey system. All of those different types of known corner positions that are already of record in the title record, that you can tie it to something in the title record. Those are corners of record that need to be tied to on your survey. And an explanation then in the survey narrative that's required for all surveys that are recorded. We have to put a narrative on the survey that says what we did, what evidence we found, how we determined the boundary locations and such. Well, with an established line, we established it in the location that the parties have agreed to. And we want to then, in our narrative, specifically state what was the issue, what was the problem that needed to be fixed, and how the landowners now established that boundary and the reason for that establishment. So those are the survey requirements that'll be required for an establishment document. And then we have boundary adjustment. And there we call it a conveyance document because boundary adjustments require the conveyance of title in order to create the new boundary. So they are over, now we're up in that paragraph 45.5, which is a new section in the code that defines here's what information needs to be on a boundary adjustment document that gets recorded. And it's a actual conveyance document, like a quitclaim deed or a warranty deed or any number of documents that are designed to exchange title or transfer title. This is a title document in the title record. So it is a conveyance, boundary adjustment conveyance document. And we'll have language of conveyance between the parties involved. Boundary establishments don't have that language of conveyance, but we have a presumption that they own to the boundary and that they're relinquishing title up to that line. Boundary adjustments include, similar to the other, any recorded document, name, address, notarized signatures, legal descriptions, tax ID of each parcel that's affected by this adjustment. So those are the existing legal descriptions. And then we have new legal descriptions for each of the properties. So this requires now surveys of all of the adjoining properties and the new descriptions of the adjoining properties. So you have existing descriptions coming in the top of this document from 2 chains of title and then out of the bottom of the document, if you perceive it that way, out the bottom comes 2 new descriptions of the same pieces of property. So the property descriptions have been rewritten now through this agreement or this exchange or adjustment of boundaries so that you have new descriptions of the 2 properties or however many parcels are involved. So we've got the existing legal descriptions and then the new legal descriptions after the adjustment is made. And there's conveyance language required because you can convey property to create the new common boundary between the parcels. So the conveyance language is that's going to be included in this conveyance document, and it will has to be legible. It has to have a legible exhibit that's attached. So that diagram that we're talking about in an establishment document, similar diagram on this new document, with the exception of an establishment only establishes location of one boundary, right? But the adjustment requires you to show where the old boundary is and where the new boundary is because you're creating a new boundary. Boundary establishments don't create a new boundary, so they only show here's the existing boundary. So you got the former boundary is shown, you've got a new boundary that's shown, and new area, frontage, dimensions of the properties included in this sketch. And then you've got the new descriptions with the sketch showing here's the property, and you can follow that description. Should be able to follow around the dimensions of your property that you're dealing with, unless it's a lot in a subdivision, because then it's just lot number 100. But we'll talk about even those descriptions as well. And a reference to the survey if it's conducted. Now, simple boundary adjustments don't require a survey. So I would recommend they get a survey done, but it's not required for a simple adjustment. Full adjustments, yes, they require a survey. So if it's required and if it's conducted, then make a reference in your document to that survey that's recorded in the county surveyor's office. And then the survey requirements for 57-145-5. 45.5 is now the adjustments conveyance document definition. The survey requirements for that kind of a conveyance document have certain elements that the other ones that the establishment does not have. It's going to show your existing dwellings again, physical features. It's going to show existing easements, rights of ways, conditions, and it's going to have a depiction of the existing and new descriptions for each parcel. So you're going to have the existing descriptions and you're going to have the two new descriptions. You don't have two new descriptions on an establishment. Survey for an establishment, survey for an adjustment, you do have new descriptions. Former boundary location and the new boundary location. So you've got both of those are shown. Establishment, no, it only shows one. It's not even a new one, it's the existing boundary. Now they know where it is, and so they can show it on a map. Size, shape, and dimensions of each one of these parcels because they changed. With a boundary adjustment, you're changing the size, shape, and configuration of the adjoining properties. So you'll have to show that those changes. And other existing or proposed improvements that impact or are subject to land use regulations. Could be anything. Every situation is a little different. So you just got to be open to anything unique unique things that come up. They may be things that the city or the county says, hey, we'd like you to show this, we'd like you to show that, and what about this? And let's make sure we show all that stuff that's necessary that will affect or have an impact on this adjusted boundary. You don't want to adjust a boundary over and find out you just violated a setback, or adjust it over and find out you just violated a minimum area requirement or anything like that. So yeah, show what needs to be shown, and anything that impacts those regulations. Yeah, we need to be cognizant and aware of those and get them shown on the survey. Let's see, then you're going to record this document. And to do a boundary adjustment, you're going to end up with this document, the conveyance document, accompanied with your notice of consent. And once you've got those things done, you can record. Once it's recorded, here's the effect. The document presumptively relocates the existing boundary by creating a new boundary, changes the size, shape, configuration of the two or more adjoining lots or parcels. It does not affect any previously recorded easement. So if you have a boundary with an easement 5 feet, a utility easement 5 feet on each side, if you move the boundary, that doesn't move the easement. If you want to move the easement, well, now that's going to check the box that says you got to do a full boundary adjustment, so that utility companies and whoever's got an interest in that easement is aware of what you're doing. You can't, the two landowners can't move somebody else's easement. Is the bottom line. Does not affect any previously recorded easement, and affixes the ownership of the adjoining properties to the adjusted boundaries. That is now their boundary between the two parcels, and all is well. That's the end goal. We've got some other slight modifications that are done in some of the other sections of the code, dealing with what a subdivision is. The definition of what a subdivision is not actually changes. That's in section 103. These are not subdivisions. So you're not creating new parcels. You're not doing things that violate a subdivision. And so we've got agricultural divisions under 605. Those were already in place. It's been simplified a little bit. The languages were simplified a little. Consolidating lots by reference to a recorded plat or parcels by meets and bounds description into a single description. So taking two parcels or two lots or several and combining them into one with a new description. That's been clarified somewhat. Anticipatory divisions, where they want to say they want to encumber a portion of their property for future sale or for future development, phase one. They want to encumber that as phase one, but not encumber the rest of the property. Well, they can just divide that out as long as they meet the certain requirements and make specific statements of why they're dividing it. Then it's exempt and not considered a subdivision at that point. That was existing code. We've cleaned it up a little bit, the language. Boundary adjustments, boundary establishments, those are not subdivisions. Public road dedication by plat, that was already there. Deeds, easements, roads, highways, that was already in the code. And other divisions authorized by law, that was already in the code. So we've just tweaked a little bit of that to make it comply or conform with our current language. 605 is a section of the code dealing with exemptions from the platting requirements. So even though you're doing a subdivision, particular subdivisions that are exempt from actually creating a plat. We've gone through and we've updated and modified a little bit of the language, cleaned some things up, where the 10 or fewer lots, that was already in the code. That's administrative land use division. You can do agricultural parcel divisions that qualify under 592502. Those are divisions that are set aside. You've got agricultural land and you want to separate out a field to sell to somebody a portion of an agricultural field for agricultural purpose. Then as you meet some certain requirements, make certain statements, then you can do that. That was already in the code. We cleaned the language up a little bit. Include a written notice of approval attached or separate from an affidavit, by a separate affidavit. These administrative and divisions, these exempt divisions, still have to have a notice of, and they call it a notice of approval. It's old code. It'd be similar to the notice of consent, but it's not really a boundary adjustment at this point. It is an exempt from plat, subdivision that's exempt from platting requirements. And record of survey is required now for all of these. You might be exempt from platting requirement, but we used to have what were called unrecorded subdivision plats, which drove everybody nuts because after a few decades, nobody can find a copy of one because they're not recorded. And yet you've got this plan and it's a mess. Try surveying in an area with an unrecorded plat, you will find out very quickly how limited the information is. And so in order to avoid that, what we're doing is requiring a survey to be done so that the survey shows the legal descriptions for each of the properties that are parcels that are created by this subdivision process that is exempt from the plat. So rather than have a recorded subdivision plat, you have a recorded survey that has all the information that the plat, probably even more information that a plat would have had. But it does require a survey for all of these exemptions. And let's see, other modifications, subdivision amendments, the amendment process 608. That one deals with, and I kind of alluded to this earlier, the plat amendment process, how we almost need to now rethink that, or retrain our brains as to when do we really need an amended plat. Because we're allowed to adjust the boundary between lots, which used to be automatically amended plat. Well, no, it's not. It's an adjustment process. So you don't have to amend a plat in order to adjust lots, the boundary between lots or between lots and parcels. And so there's not as much of need for these amended plats. The only time that the adjustment process even mentions amended plats is if they're required by ordinance and you're doing a full adjustment. You're affecting a public easements, public rights of way, public roads, things like that. So if you're doing a full boundary adjustment with lots in the subdivision or between a lot and a parcel, and there's an ordinance that requires you to make a amended plat, yeah, you'll make amended plat. But without the ordinance requiring it, and really, when you see the contents, there's really not much need for doing amended plats like we used to do. All it did was just change the location of the boundary, right? In a boundary adjustment equivalent. Now, if you're doing an amended plat that's increasing the number of lots, well, of course, you're going to have to do an amended plat because now you're doing a subdivision. You're taking 3 lots, turning it into 4 or 5. Yeah, that's a subdivision creating additional lots. But if you're coming away with the same number of or fewer lots than you started with, then that's an adjustment. And that's kind of the difference between the two, the breakover, as to when you're going to really have to have an amended plat. And that's to create new lots. And even then, it's possible to do that, to make some tweaks on the amended plat process that actually makes it a better process. Right now, we record an amended plat that says, that creates new lots and exchanges and is prepared to exchange title, but then we end up having to do a separate document that is actually the title exchange. Well, the adjustment process actually combines them so you can do them on one document. And that's one of the goals here, is that we have one conveyance document that goes in the title record, whether that be in the form of a plat or in the form of 8.5 by 11 sheets of paper, however you want to envision it, based on the circumstances and the detail that's being presented. You're going to record this thing, and it's going to be one document that is going to do all of it. It's going to, all of it, including the actual conveyance language. And so if you put the conveyance language on an amended plat, well, yeah, it'd be a good idea, because now you've got one amended plat that does everything, rather than the way we've been doing it with two documents. And not following through with the second document. Now you got a plat in the record and they never conveyed the property. And we've all been, you probably all have seen that kind of a situation. And that's what we're trying to avoid by doing one document. Let's see. Notices, that's all the same process in there with the 608. Land use authority may not approve an amendment if you actually do an amended plat. That's all really the same requirements. We just cleaned up some language in there a little bit and clarified that this minor amendments where no hearing is required was current code. We cleaned up a little bit there in the language to deal with internal lot restrictions, consolidations, where you're reducing the number of lots. You don't have to do public hearings for that kind of stuff, even though you're dealing with other entities that might want to throw you into that category. You shouldn't have to go through the public hearing requirements, at least. You might still have to go through notice processes and things. There's going to be some flexibility there. Each designed for its own situation. So in the handout materials that you've received a link for, has this boundary establishment agreement sample. These are examples that we put together based upon the code, and what the code says, as then we've formulated a boundary establishment agreement. Here's the form that you could use to produce these agreements. Now, these are not hard, set in stone. They're flexible. All we're saying is, in order to take these parts and pieces out of the language in the codes, here's a way to do that. There will be unique circumstances that will arise, and there will be situations when you'll need to modify that form somewhat to accommodate your situation. But make sure that you're including the information that's required in the code. And that's why we've done this example. And we've done an example for boundary establishments, another example for boundary adjustments. So quick run through these. We've got your boundary establishment agreement, similar to a recorded deed, one recorded send to blank. And you're going to enter into a section in the code that requires your signatures of all the parties, the address of the parties for assessment purposes. That's that first paragraph, which is a typical opening paragraph for any kind of an agreement, and even similar to a grant deed, warranty, quitclaim, those kinds, except for here we're talking about party one, party two, not grant or grantee, because they may be exchanging parcels. They may be transferring or conveying one way to the other, but either way it comes out, there is a conveyance from one to the other and from the other to the one, cross conveyance language. And then we have a statement in here that describes that uncertainty, the ambiguity, or the dispute that's being resolved. What is the dispute that's being resolved? Is it deed misclosures, conflicting surveys, transcription errors, conflicting occupation, or perhaps a dispute that is resolved through mediation or a court order that says your boundaries here, go home. Yeah, that's where your boundaries, and we've got a part of the code that says that you record that court order in your title record, and that court order is to be treated as a boundary establishment. It establishes the boundary between the parties. And there's other requirements in here, statements by the owners. As a result of said ambiguities, and uncertainty or dispute has arisen with regard to the location of the common boundary between party 1 and party 2. Parties desire to settle the uncertainties or dispute by entering this boundary establishment agreement, fixing the boundary location with certainty per code 57-145. Direct statement of here's what we're doing, here's why we're doing it in paragraph C, and paragraph D is saying, here's what we're doing. We're agreeing to do this. And here's the existing descriptions, the current descriptions of each of the parcels that are involved. On the second page, the agreement itself, you're going to have the new legal description of the property. Or not, no, this is a newly, an establishment, it's a new legal description of the boundary that's being established. So there's no new property descriptions. It's just, here's our boundary. And that's all that they're doing. So if we were to survey this piece of property, we'd survey it like we always did. But when it comes down to that boundary, we know where it is because they've agreed it's right there. And we have the information necessary to locate it on the ground. The boundary establishment answers the where is the boundary question, not what is the boundary, who owns to the boundary, who owns the property on either side of the boundary, the who, what, where, the who and what questions. That's title law, where is the boundary is boundary law. Two separate pieces, separate bodies of law that we're dealing with these establishments and adjustments. Let's see, then we've got boundary establishment document is going to have the visual graphic that's prepared that shows certain things that are required in the statute. And it's going to have, if you conducted a survey, there's going to be a paragraph in there that says, yeah, and by the way, we did, the underside parties mutually recognize that they did a survey and that they make a proper reference to that survey in the document. And fairly straightforward. So you got a graphic that's attached to the document itself. And in this particular example, it's an 8.5 by 11 document with an 8.5 by 11 graphic that we'll see here in a few slides. And that graphic is attached. And if they did a survey, make a reference to it in one of the paragraphs. Then we have, this is kind of a combination of several parts of the code, language from different parts of the code. 57-145, that says that they have to take possession, they have to take actual possession to the agreed line. Each owner has to cultivate, or they have to cultivate up to the visibly marked line. And over in 522 and 523, something similar says the establishment that complies with this section conveys ownership of the adjoining properties to the established common boundary. So we've taken parts of the code here and combined them into one paragraph. That's the way we did it in the sample. You can modify it any way you want. And as long as we have these particular languages, we're trying to put the parties on notice that here's what you're doing by signing this document. They agree to treat the boundary as their common line. They agree to take possession to that line. It's going to be a line that's visibly marked. They can cultivate up to it, and they can extend their ownership is intentionally extended to that line. And then there's a paragraph of acknowledgements, and we find acknowledgements kind of scattered in several different places. 57-145 has a paragraph 2, 8, and 9 of that code deal with some of these acknowledgements. And we've boiled that down into a paragraph, paragraph 5. and kind of boiled that language from paragraphs 2, 8, and 9 down. And I think there's another section here as well. Yeah, over in 522, 523, paragraph 3A and B talks about if it's not so subject to review, then it's not, it doesn't require consent. But yet with that, then there are chances that they're taking. They may screw something up, and it's not the fault of the land assessment people, or the land use authority, if they mess something up. People, we talked a lot about what if people don't conform to the code and they screw something up? Yeah, people do that, and we couldn't write a code that would prevent somebody from screwing it up. And so we had to just acknowledge the fact that sometimes people are going to not comply with the code and going to screw some stuff up. And if they do, they'll have to deal with the consequences. And hopefully the code gives them enough provisions so they can fix their screw up without too much pain. But you can't fix everything, and you can't prevent everybody from themselves. Then you have to have, of course, your acknowledgments on your from the notary for signatures. Boundary adjustment, conveyance documents, similar agreements, slightly different. Boundary adjustment agreement has, of course, the intros, party 1, party 2 things, similar there. A notice of intent here to conform to 5745 or 0.5. It's got a section here with the new descriptions or the existing descriptions coming into the adjustment. Party 1 owns this, party 2 owns this, with their descriptions and references to their recording information. And on the second part of the agreement, we've got paragraphs 5 and 6. We have to have sufficient language to convey title from one party to the other for the new descriptions of the adjusted descriptions. And that's what we see here. In order to establish the adjusted boundary, party 1 hereby relinquishes, conveys, quit claims to party 2 any right, title, or interest and estate party 1 may have in the property described in paragraph 2 above, which lies within the adjusted boundary of party 2 adjusted property. And the reverse in paragraph 6. So that's your cross conveyance language. Then we have to have this visual graphic, and we've prepared a few different exhibits. This is an exhibit for a simple boundary adjustment between 2 lots. And so we have a lot 100, lot 101. We're going to show, well, here's the boundary to be adjusted, the dashed line, that's the existing boundary. And then you have the boundary after the adjustment, or the boundary before the adjustment and the boundary after. And we have the dimensions before and after. And we have down here within the document, the before the area before the adjustment, area after the adjustment, things like that that you need to put on the document that makes it easy for that person behind the counter to look at it and say, the administrator behind the counter to look at it and say, yeah, you've got there, we've got the zoning information, the minimum area requirement, maybe minimum frontage, 90 feet. They can look at it and say, okay, you held 90 feet, you meet the minimum areas. Yeah, no violation of the zoning ordinance. You're not moving the street, you're not moving any easements, haven't violated any zoning ordinances. Here's your notice of compliance, go record. It should be that straightforward, simple boundary adjustment. It's just a quick over-the-counter review. I used to do these at West Valley City, and you didn't even have an application to fill out. They just looked at it. You just said, yeah, here's my zoning, here's my stuff, here's this stuff, no improvements in the way, whatever. And they look at it and say, yep, you're good to go. Here's your certificate. Attach that to your establishment document and record. Straightforward process. And this one also had a reference to a survey as an example as well, which is required in the code. If you do a survey, put a reference on your sketch and make this reference in the document itself. Oh, this is an adjustment conveyance. I'm sorry. The other one was, oh, that's an adjustment conveyance as well. Boundary adjustment, simple adjustment, yeah. So any adjustment document requires a conveyance. But you'll also have to do a sketch on an establishment as well. Full boundary adjustment, in this example, they're going to want to propose to build a barn. So they need to move the boundary, but it's got an easement along the boundary, a public utility easement that has to be moved. Well, public utility easement, you can't check that second box, so you're going to have to go through a review process. You got to go through a full boundary adjustment, which is what we've titled this one, a full boundary adjustment between two lots. So they're going to come up with an old line, new line, same thing, zoning ordinances, this minimums, and make sure you're going to maintain those minimum requirements and meet those minimums and have enough information on this document or this graphic so that somebody can pick it up and say, okay, yeah, oh yeah, I see they're moving the line from here to there. And yeah, they meet the ordinances. So even with a full adjustment, it's a nice, simple document. Now, full adjustment also requires a full survey. So when you do the survey, that has to meet those certain requirements as well. And that survey will be submitted with this document, including the cross-reference. So it's a mandatory survey on a full adjustment. And that's because you got to show existing buildings and existing improvements and all that kind of stuff to make sure that you're not, that this moving the easement is going to conform. Here's a 10-foot easement. Well, gee, if I have a building that's only 5 feet off the line, now I got a building over I'm moving an easement to put it under a building. I wouldn't recommend that. So, that's the kind of stuff they have to look for on a full adjustment. Make sure that we aren't creating more problems than we're solving. Cross-reference to the survey. And then in the document, once you've gone through that approval process, you're going to come back with a notice of consent. And the code's a little different on a notice of consent requirements for a simple adjustment are slightly different than the notice of consents for an adjustment document. For a simple or a full, excuse me, because you only need them on adjustments. So a simple adjustment has an opening paragraph that's a little bit different. Simples refer to this subparagraph 3, where the fulls refer to subparagraph 6. And then it's going to have here's the requirements. Here's the 3 boxes that we check. No public right of way. Does not affect public right of way, doesn't affect easements, or result in a violation of the land use regulations. So, and then a notice of consent. This would be the notice of consent for a full boundary adjustment. Has a few more requirements, of course, here that have to be met for the full adjustment that aren't met. So it's a little bit unique, a little difference between the 2 consent languages that we're suggesting. And keep in mind, these are suggested languages. You can add to, modify. Be careful if you're dropping it out, though, because most of the language we're putting in here is language that is essentially required by the code. Now, you can reformat it any way you want, but it's language that the code says needs to be there. The notice of consent being an administrative act, number of different things like that. And there are several codes that are built into this paragraph about the administrative act and the effect that, yeah, it's an administrative act to get your approval, but that does not constitute land use approval. It does not constitute the fact that they can always go back and reevaluate, and they may end up withholding about building permit if it's found that you did violate some ordinance that with information that was maybe withheld when the consent was given. Because they only give the consent based on the information given to them at the time. And so if you don't give them all the information, it can throw the notice of consent into question. And if that happens, no, you're going to be held to the facts on the ground. And the land use authority is not going to be held responsible for any failures in that part. It's your own failure. Now, here's an example then of a simple boundary adjustment that's done in the form of a 24 by 36 plat. I became aware in the process of going through this that from Shelley over in Duchesne County, that they've been recording boundary adjustments in the form of a full-size plat that contain most of the requirements that the new law requires. And I'm anxious to see what, now that Shelley's had a chance to review this a little bit, to see what her comments are. They've been doing something similar to this, but not quite exactly like this. I think it was everything's there except for the cross conveyance language, I think, is about all that's different, and the notice of consent. But you have a diagram that shows the details of the information, where the old boundary was, where the new boundary is, any movement of easements that you're changing, location of improvements, zoning ordinances information, area requirement information, things like that. But there's the diagram that's on a full-size map this time, not just an 8.5 by 11 sheet of paper. And then here's the agreement language, the agreement between the parties, their existing descriptions. There's new adjusted descriptions with their agreement language on that they've agreed to adjust their boundaries like this, according to these descriptions, and a couple of other agreements, acknowledgements that are included there. Owner certificate, where the owners will actually sign. You got 2 owner certificates on this map. So each owner signs for that cross conveyance language that's included in the on the document with their acknowledgement, the notary public acknowledgement. And over here was the notice of consent, and which is like the notice of consent language that was on the 8.5 by 11 paper, but now it's on a bigger map. So all of those are and then also the surveyor certificate. We added, we took the standard surveyor certificate and added a let's see, they said this plat accurately represents said survey, and to the best of my knowledge that this boundary adjustment conveyance document is made in accordance with 57.145.5 between adjoining owners adjusting their existing common boundary. So we added that into the surveyor certificate. Now with a simple adjustment, no, only establishments. If it was a boundary establishment plat, you'd have to have some language in there about them agreeing to establish the one boundary, and having the language of in the surveyor certificate or the narrative, the surveyor's narrative, which is actually over here on the other side. There's a surveyor's narrative that in that narrative, the surveyor would have to make a statement of why they're entering the agreement or the establishment agreement. And then recorder's information to record the plat, record this simple boundary adjustment as if it's a plat. Could be, it's basically an amended plat, right? If they're lots, if they're parcels, it's what we used to call a boundary adjustment, a parcel boundary adjustment. No, it's a simple boundary adjustment in the form of a larger document that gets recorded. All we're talking about is the difference in the size of paper. All of the elements are there in both. You can record one document, 8.5 by 11 documents that we have in one's example, or you could put all that information on the face of a larger format and record that. It's still the same information on the recorded document, either way. And yeah, one might go in a drawer, but it's probably going to be available on electronic download. And the other one, 8.5 by 11, is going to end up, electronic download too. So, the distinction between what a boundary adjustment plat or adjustment document, no, they're conveyance document either way, because it has language of conveyance on top of it or included. I'm going to wrap it up there and open it up to, I haven't been watching on the chat to see what all questions might have been posted, but let's take a period now where we'll open it up, and I'll let the panelists join in and in some of the answering some of these questions, comments, or raising issues of their own, and we'll see where we go for the next half hour.
Hey,
And
John, thank you very much.
Rob did say that if we need to go beyond time, we might be able to schedule another session to just record more Q&A.
Yeah,
So,
absolutely. If needed to, we can even stay on a little bit longer than what the webinar was originally recorded. Anybody's welcome to stay on that has that additional time. Right now, we do have 28 open questions in the Q&A queue. So if you guys as the panelists just want to simply pull up the list there, and you can start going through those open question and answer items. And if anything is needed on the technical side, just let me know and I'll jump in.
Terrific. This is Court. Yeah, there seem to be a lot of questions, John, while you're talking about the boundary establishment and how somehow it doesn't create new legal descriptions. One of the questions that I answered privately that I thought might be good to pose to the group here was, can you provide a hypothetical scenario for when you would use a boundary establishment? In the notes to the checklist, it says that a boundary establishment will not create new descriptions for the property. I can't imagine any scenario where a boundary establishment would not change the record legal description to at least one or maybe both properties. And there was another related question in the chat about that same issue. It seems like if we had a conflict of boundary, a deed overlap, if you will, and we resolve that conflict, somebody's got to get a new description, don't they?
one would think. From a title perspective, yeah, that's you would ideally have new descriptions on everything that where they've altered a boundary or fixed the location of a boundary other than what the current record shows. But boundary establishments are a common law concept that's a contractual relationship between the two parties. All they have before them is, we have a problem with this boundary. They don't have a problem with any of their other boundaries, just this one. And to then require them to have surveys, legal descriptions of everything now starts to open up more cans of worms, and you end up going oftentimes spiraling down into exposing other problems, and it just becomes this recurring dovetails of issues. And the courts are very clear that two landowners have the right to settle the location of a boundary between them. And that's what the boundary establishment is designed to do. But the caveat is they have to have a reason to do that. It has to be an uncertainty dispute or ambiguity in their documents. And it can be a number of different conflicts. You can even hire two surveyors and get two different answers, right? We all know that. Even surveyors know that. And if you got two surveys with two different answers, the only recourse the landowners have on that boundary that's now has an appearance of a dispute, the only recourse the landowners would have would be to now litigate a difference, or to go through some formal mediation or something. Even mediation, they're going to come away with saying, okay, yeah, we've settled this question and here's our boundary. We've established the location of the boundary. But they haven't done that with all the other boundaries. They haven't even surveyed the other boundaries. You only have this one issue. And so it's a mechanism in the law that's been allowed for, if you look back, we've got hundreds of 150 years of these documents that are actually already in the record that fix the location of the one boundary, but they don't change the legal descriptions at all, because we don't know where they sit within those legal descriptions, and no surveys have been done of the entire perimeters to be able to create a new boundary description without additional expense and delay. And they just want to fix this problem and go and be done. And that's a simple way to do it. That's what establishment is designed to do. It's definitely antithetic from the title perspective. We'd like to see new descriptions, but it's just simply not required under the law. And we can't really require them to do more than what the law encourages them to do. Once we start doing that, then they get to a place where, okay, well, we'll just treat it like this, and we're not going to spend the $1,200 or the $2,000 to have our surveys done and new descriptions and documentation. We're just going to spend a few $100s and say, here's our boundary, and get it and get it in the record fairly inexpensively.
This is Zach Shaw with the Salt Lake County District Attorney's Office on the panel. I will note that the bill SB 104 does require for boundary establishments legal descriptions of the current legal descriptions of the two properties, as well as a legal description for the new boundary that the parties have agreed upon. So there is a requirement for a new legal description for the agreed upon boundary for boundary establishments, if that helps.
Yes. Oh, yes, definitely. And that's where now, yeah, you're talking about they know where the line is. They just want to put it someplace else. They want to create a new boundary and shift it over, relocate the existing boundary. That is going to be a boundary adjustment, requires reviews, and it requires new descriptions of both properties.
And boundary establishment also requires a legal description for the new boundary, or for the boundary that's
yes, a new description of just the boundary itself. Yes.
Correct.
Mm-hmm.
This is Shelley, Deschamps County Recorder. There are a lot of questions in there. Some that and John and I have some very healthy discussions about these establishments, and so the recorders still have some concerns about the language that's around this establishment. From everything that you have presented to us today and all the discussions that we had working on this, I think it's the expectation of John and the surveyors that the establishment doesn't really do anything. It's recorded just to put everybody on notice. It doesn't move a line. It doesn't change acreage. It doesn't change the legal description. But there is language in your example of the establishment agreement that is conveying language, and the recorders, I think, have some concerns with that, because if that's presented to our office for reporting and there's conveying language in it, we feel it's our responsibility to change their legal description and calculate their acreage according to that new description. And so I think that there's still some concerns here that will probably work out. As with any new bill, right? Like this just happens. Things change, and it takes us a little while to figure out all of the kinks and the quirks and work together to do that, just in time for somebody to change it for us again. So I don't know that we need to answer all of those issues today, John. There were a significant amount of questions about the purpose of the establishment.
The establishment is something that the surveyors are concerned about establishment, because all establishment does is says where the boundary is,
right.
Which is not a title question at all. Title documents don't tell you where the boundary is. They tell you who owns up to it, and here's some evidence of where the boundary is. But from a surveyor perspective, yeah, there's evidence in the title record. There's also evidence on the ground, evidence on prior surveys. We have to take all this evidence into consideration to say, here's where the boundary is. And the boundary establishment will tell the surveyor where it's at. But the presumption in the law is that the owners already owned to their boundary. We didn't know where it was. There was ambiguity, uncertainty. Now after the agreement, we know where it's been established to be, and we know where. And so it's the surveyors, we need that information to locate it on the ground. But from a title perspective, nothing's changed. Like you said, doesn't change area, doesn't create a new boundary, so it doesn't do any of those things, doesn't create a new description. And the courts have said that consistently for 150 years, that it's not a matter of the statute of frauds, doesn't violate statute of frauds because it doesn't involve a conveyance of property. Now, in order to make it so that it is so that it satisfies the title company's requirements or concerns, where we added language in there that said that it's presumed to convey title to the line. Just the act itself of entering the agreement and establishing the line is presumed to now everybody owns to that line. And so there's a presumption of conveyance, but in the document, if you read through that sample, you won't find any conveyance language in the document itself. There's not like the cross conveyance language you see in the agreement or the adjustments. And it's a mind bender from a title perspective, always has been. And that's what started us down this road in 2001. Is trying to define what these documents are that have always been common law principle, and we put them in statute form and made people aware that, oh, there's this other kind of agreement out there, and what do we do with that? And it's been a confusing thing since.
Should we just kind of go in order? There's a question, it looks like, on a gap resolution. Darren Farrar asked, is there a limit on the size of a boundary line agreement? For example, I'm aware of a property that has a triangular difference that is 25 feet at the wide end. Could this gap be resolved with a boundary establishment?
Well, yes, in a sense, yes, but there's, it's why do you have a gap? That's the first question, because gaps are really a legal impossibility, because a gap would be three pieces of property. And so you got owner A, you got owner B, and then you got owner C that would own this gap. If it is, and in order to have a gap or to have a third parcel, you have to have intent of the landowners to create the third parcel and retain ownership of it. And you don't have intent from the owners to create that gap. We call it a gap because we have evidence in this deed that says the boundary's here. We have evidence in this deed that says the boundary's here. And we find out that, well, one of these two deeds, if not both of them, are wrong, because that's not where the boundary is. It's either here or someplace, hopefully between the two. But you have unresolved conflicting evidence in the title record. And in order to resolve that conflict, it's not, if it's a conflict in the title record and it's an evidentiary issue, we're back to, well, where is the boundary? Is it where the deed A says, or is it where deed B says? Or is it where surveyor A says, or surveyor B says? Or is it on the occupation line that's been there for the last 80 years? Those are all evidence of where the boundary could be. And boundary principles, boundary laws are designed to resolve the conflicting evidence that leads a surveyor to the conclusion of, well, based upon all these conflicting evidence, here's where the boundary is. If a surveyor fails to do that, if the boundary law application of the legal principles fails to answer that where question, then we're left with an actual title problem with a gap and a title issue that has to be resolved through title law, which is usually a quiet title action and goes that route, which was going to require new descriptions for both properties to resolve. But you're resolving a problem in the written document, ambiguity in the deed. That's really what it comes down to, is really ambiguities in the evidence and conflicting evidence, and applying the appropriate rule of law that's designed to resolve that particular type of conflict. That's why it's not an easy question. It's not always a title answer. It's not always a boundary law answer. Can be a combination or any one or the other, depending on circumstances. That's the long answer to a short question, isn't it?
John, there was one, Is there a way for a land use authority to challenge a boundary establishment if it is found to affect easements, zoning regulations, etc.?
Boundary establishment, they won't even see it. It's not even brought before them because the landowners have this right to go ahead and establish a boundary and the right to create screw-ups and problems. And so there's no review at that point. Now, there are caveats in the code that say that now those people who have established this boundary come in to get a building permit for something. Now is when they're in front of that counter, and that review will look at, was there a violation created by this establishment agreement? And if so, then no, you can't get a building permit until you resolve the problem that you caused by this agreement. So it's an after the fact solution. We don't like to see them that way, but you can't stop people from making their own mistakes.
And that was a policy decision from the sponsor because there was certainly discussion when we were negotiating and discussing this issue about having land use review prior to boundary establishments, and that was definitely a policy decision that I think it was based on historically in the statute. Land use review is not required for boundary line agreements historically, and also just moving forward. There was a definite policy decision that was made to not have land use review in the up front, but instead, as John mentioned, to have that addressed on the back end when building permits or land use applications were filed.
Yes. Mm-hmm.
There were several questions in there on kind of the municipal aspect or the county aspect of this, dealing with who's going to determine whether or not easements are impacted. Is it just going to be a look at the plat, or is it going to be a full title search? What's the definition of some of those for specifically easements?
Yeah, with the full adjustment, it's going to be a lot more obvious because you've got a survey requirement. The surveyor's got the responsibility, the duty to discover those easements, show those easements, whether they're of record or just easements apparent. So that onus falls on the surveyor for the full adjustment that requires a survey. We got that little category in there in the simple adjustments. The survey is not really required, but the situation, the complexity may almost mandate a survey. Almost, you just need to have a survey because of the complex issues. So when the person comes in for a simple adjustment review, you look at the boxes. Are there easements? Well, they don't have a survey, so how do you know if they do or don't have an easement? You almost have to take that on faith. Now, it's one thing to have a subdivision plat that shows easements along the perimeter of a lot line or something that, yeah, the record, it makes it really obvious that, yes, there's an easement involved here. Okay, it's a full subdivision. You need to get a survey. But other than that, when that person comes in for that application for what they think is a simple adjustment, if there's information available to the land use authority to say, wait a minute, I think there's some easements involved here, then they can step in and require them to show those easements. But without, and I don't even know what some situations may arise where that happens, but a lot of times they're just not going to know. And they're going to have to go on the representations made that there are no easements involved and send them down the simple adjustment road with their notice of consent. Because the code does not allow them to do anything other than that. If they have evidence that there are easements affected, then yes, they have to go full. Otherwise, it's a simple. And there's no onerous on the the land use authority to do the research. The responsibility is in the owner's lap. And so if they send them down the road with a simple adjustment and their notice of consent, when they come in to get the building permit, find out that they violated, same thing as with an establishment. They can say, no, you're going to be required to fix this problem, go through the full adjustment process if necessary.
Can I add to that, John? It is the land use authority that's determining, that's doing the review, determine whether it's a full or a simple boundary adjustment, and to determine whether there are easements. So I would think that the land use authority, to the extent that the land use authority has information either presented by the applicant or in an independent subdivision plat or in an independent land use application that was previously submitted, if there are indications from that land use authority that this would impact easements and so forth, then the land use authority could determine there is an impact. You need to go through the full boundary adjustment process. If the land use authority can't determine that based on the information it has from the applicant or from the property owner and from its own information, then I think John's right. It would go through the simple boundary adjustment process, and then if there is a land use application or a building permit application later on down the road that where a full survey is required and it's determined, oh, you have a problem, you've impacted easements and whatnot, then yes, they would need to go back and fix that problem at that point.
There's another question from M. Kazir, kind of related, says, what is an internal lot restriction and how is that identified?
Can I just mention one other thing before we move on to that question? That was another policy question or issue that was decided when we were negotiating with the sponsor. Should surveys be required for boundary establishments? Should they be required for simple boundary adjustments? And it was a policy decision, and the sponsor was very clear on that. That hey, if it's not impacting right of ways and easements, then we want to allow them a boundary adjustment or simple boundary adjustment without a survey. That was certainly an issue that was discussed, and that was a policy decision that was made from the sponsor. So anyway, let's take that next question.
Yeah, so thank you. M. Kazir, what is an internal lot restriction?
Anybody want to take that one? To me, it can be a number of things. It can be a slope restriction, could be a wetlands area for a no build, can be any kind of a regulatory imposition on the property that's been imposed on the property. And usually it's property specific through, say, a subdivision approval process. They've outlined a certain no build restriction area. Well, it might be a no build restriction because of a slope requirement. Well, if they go in and modify the slopes of the land, they might be able to go in and adjust that internal lot restriction to shift it over so that that they've reclaimed land now that's less than 30%, let's say. So internal lot restrictions are usually regulatory issues, and you can alter the conditions and then get a different application on the regulations. That's my understanding. And it can be a lot of different things.
John, there's a question. There were a couple questions. Sorry, my questions are jumping now. So following a boundary establishment, the county recorders and assessors will then write new tax descriptions instead of the owners. There was also one about Greenbelt. So from a recorder perspective, if establishments don't change a line and don't change acreage and essentially don't change anything, it's just putting everybody on notice that this is where they agreed their line to be, then no, we are not going to write you new descriptions. Recorders do not write legal descriptions
Yeah,
for people if we can help it. And so then no, it would not affect greenbelt either. If it's not changing anything, then no.
that's absolutely correct. Yeah, there's no need to write a new description. It's the same property. All you do is index the establishment document, index it to both parcels, both adjoining parcels, or however many that are affected by the agreement. You just index the property so that it shows up in their abstract and nothing changes in the legal description. You could put a caveat in there that says, said property being subject to an agreed a boundary establishment agreement that affects the east boundary, something like that. But like you would reference an easement or some other extenuating document. But it doesn't change the legal description. The assessment doesn't change. The parcel number doesn't change. You just index it in the abstract, and you don't have to you don't have to change it in the GIS map. Nothing. It just is what it is. And most boundary establishments, you wouldn't notice the difference unless you zoomed way in on a GIS map either way, because they're trying to establish an existing boundary. Some of them have big conflicts. I've seen boundary agreements made when they've tried to resolve a 150-foot discrepancy. But it just is what it is, and that's all they want to do is fix that boundary.
I think from a practical standpoint, the way we're looking at this as the title industry is, if we see a boundary establishment document recorded in the chain of title, we're going to probably require some additional work to be done. Some new descriptions to be crafted that we can determine if they're insurable, and there may be more involvement needed from party one and party two to establish and to put that of record, if you will. So we think it might end up being a two-step process for somebody to then turn around and sell their property or do something.
Yeah, it would be appropriate to just either got one or two choices. You're either going to put it in Schedule B Section 2 and not insure it, or you're going to try to make it part of Schedule A and include it in the description, and then it's just going to be subject to this agreement. Actually, in reality, you've got less conflict or less risk associated with the agreed boundary than you do all the other ones that you've already been insuring. So that's where your most your risk is. The risk has already been resolved through the establishment agreement on that particular line. So from a risk association standpoint, you probably had more risk before the agreement than you do after.
But in my experience, most people will want to know what they're buying. And if the legal description of record doesn't match what they think they're getting, because now there's a fence there, they're gonna want some kind of resolution that they've been, cultivating or doing whatever to establish that. But as part of that, I think I just see that may be a practical, helpful thing, but at the end, we may need some more work to be done to ensure it. And if you're right, John, we could leave that as an exception on their title to say, hey, this was your historical legal description, but because of this subject, we don't know what it is really without some more help and some more work, because there's this now recorded boundary line agreement. Boundary establishment agreement that now that your legal description may not be in what you think it is. So that's just my thought, and where some of these may come down as they're working through that. But we always encourage people to get surveys anyway. So
yeah, and it's kind of that way with any kind of survey you do, is it's going to expose differences in measurements, and the areas aren't going to be the same, and you're going to have record and measured dimensions around the other boundaries as well. But at least we know where the one boundary is through the establishment. As long as they've done a good job on the establishment record, yeah, we'll at least know that one. That one's easy to survey because it's already been done. It's all the other stuff that we have to now go through all the evidence and sort it all out.
John, maybe this could be the can be the last question. I know we're running out of time, but this was asked twice. Can a boundary establishment agreement be done between 3 or more owners with property adjoining the line?
Oh, absolutely. Like I say, I did one with seven different owners, all signed off on the boundary establishment. Yeah, it can have multiple parties involved. It's just that each parcel has to be defined, so you know where to index the establishment agreement. So it gets properly indexed on each parcel that's affected by each owner that's signed, and then you can include them all in one, and have one description of a boundary that may encompass 3/4 of a parcel. The boundary, it might have several boundary segments with different adjoining properties along each segment. And maybe one owner on one side and 3 or 4 owners on the other side. Can be any kind of sequence like that. I'm just going to have each owner sign that's to their effect and their agreement.
Okay,
If I could, Rob, I know Rob's going to interrupt really quick, but if I could just say one more thing. First off, thank you very much. I appreciate the opportunity to be on the panel and to participate with all of you, and I appreciated the process of us getting to this point. I don't know that we're quite done, but as a standards board member, I think we discussed also during the session when there was still some issues that we felt like maybe needed to be resolved, that maybe some of those could be addressed through the standards, the county recorder standards board, and clarifying some of that or defining some of it so that the county recorders were being consistent across the state. So we, as far as I'm concerned, we will continue to work on this.
Yeah, I'd like to add to that as well that Utah Council of Land Surveyors, through our legislative committee, we also have a standards and ethics committee that has produced standards for plats and surveys and things like that. We are already looking at how we're going to produce the boundary agreement and adjustment standards of practice for surveyors that will go through this same documentation, have samples and things. If anybody's got comments on these samples, please email me. I can be reached at CPLS Inc., Cornerstone Professional Land Surveys Inc., cplsinc@gmail.com. And I would welcome any input to those samples that we threw out there. If you've got something you'd like to see on there or some recommendations, please let me know, because we'll be developing those standards from the surveyor's perspectives at least. And we'll try to produce those out so that everybody can see, here's what we're expecting to be able to deliver. So with that, I want to say thank you very much for everyone's attention to this matter. And the real push that we're after here is to have a statewide standard that we can all be working from, and so that a surveyor can produce a document that's fixed and we can submit it in any municipality, any jurisdiction, and expect the same results or at least similar results.
Thank you very much, John, for your presentation, for the members of the panel, of course, for all of their inclusion today. I do have record of all of the questions that were asked, as well as those that were answered. So those that were outstanding and that we didn't have time to cover today, I will make sure John and the members of the panel get a copy of those questions. And if you guys didn't want to provide some answers for that, I will ensure that that gets out to the list of registrants. And just as a reminder, everything here from the webinar recording, the support materials, any of those type of additional questions, record of everything here will be sent out with links and attached documents to all registrants. All of those items will also be posted on the Land Use Academy of Utah website, so I'll ensure that you have links for all of that as well. Once again, just thank you everybody for attending today's boundary adjustment webinar. The Land Use Academy of Utah had the opportunity to host this with the Office of the Property Rights Ombudsman with funding support through the Land Use Training Fund. Thank you very much to our presenter, John Stahl, and to all of our Q&A panelists support for Shelley Brennan, Court Ashton, and Zach Shaw. Really appreciate everybody's time today, and I hope everybody has a wonderful rest of your week.
Thank you, Rob.